Ladies and gentlemen, welcome to the next episode of the Schmoozin with Forouzan podcast. Super excited about today's podcast. Today's interview is going to be interesting, especially if you are a plaintiff's attorney, especially if you're a plaintiff's attorney who's just starting out or have a lot of experience. Why? We are interviewing a former defense attorney, former insurance defense attorney, who now works on the plaintiff side, on the light side, for Panish, Shae, Boyle, and Ravipudi, Mr. Paul Traina. Paul, how are you?
Daniel, I'm great. Thank you for having me here today.
So Paul and I met at Panish's live event. It was in Utah. It was a wonderful seminar, very well crafted seminar, incredible visuals, incredible dinners, incredible everything, actually. Everyone at the firm, including Paul himself, was super generous and super kind. Learned a lot there. And I met Paul, and he said something very interesting to me, and it caught my attention. And I think it's why we're here today. Paul said to me, the way the firm he's working at now does things are very progressive. That was literally his words. And he followed up with that, indicating that he's a former defense attorney. So I said to myself, geez, imagine the wealth of knowledge and just the perspective Paul must have coming from defense work and then working at the plaintiff's firm, and that one of the preeminent, if not the preeminent plaintiff's firm. So there's probably a lot of good information in there, probably a lot of intriguing information there. Anyways, I've spoken too much. Paul, please let us know, how did you even get started in law in the first place?
You know, it's funny. I started thinking about getting into the legal profession when I was in sixth grade. And I actually had a young lady, a girl that I liked, and we were going over for a birthday party to her house, and her dad happened to be a lawyer.
Wow.
And at that point in time, when you're in sixth grade, you don't really know what you want to do, of course. But I sat down and talked. We were talking to him, and I thought, hey, this guy's really kind of cool. Boy, I think being a lawyer looks like it would be a great thing to do. And so that was in my head when I was really young. And as I got older, and I think is into high school, I made the determination that that's what I wanted to do. And my idea is that look at all these different legal shows that you watch and how lawyers are helping people. And so that's kind of what how I got into law, or the direction that I wanted to go.
How did you end up doing insurance defense?
Well, when I graduated from law school, I graduated from law school in 1991, and there was a firm that's still in existence today. It's called Harrington, Fox, Dubrow, and Cantor. And that firm did insurance defense work. And at that time, when I graduated from law school, it wasn't like I wanted to be a plaintiff's lawyer or defense lawyer. What I wanted to do is just get a job, because I had a lot of money that I had to pay back in loans, and they happened to be a firm that wanted me at the time. And so I started out on the insurance defense side, and I want to tell you, I was there for about 6 years. And as you know, when you're anywhere for 6 years, you learn a lot of information, and you learn a lot of stuff. And during that time, one of the great things about being at an insurance defense firm that I still tell my associates now that I work with is that when you're working there in your early years, you learn how to work up a case for trial. And what I mean by that, when you're insurance defense side, you are required, whenever you get a complaint in, you take a look at it and you write to the carrier and you say what your recommendations are going to be. I recommend we file a demur. I recommend we don't. We file an answer. Let's send out discovery. And when you send out discovery, you get that information back. What do? You write the carrier. So it forces you to, you're up on your case all the time, because you're getting information in, you have to report to the carrier. You have to get the approval from the carrier to do the next step, and you have to make recommendations. And so during your 4 or 5 years, actually your first couple of years, you become a pretty good lawyer, because then you say, well, we got to take depositions, and then you have to summarize the deposition. You have to send the summary to the carrier and make other recommendations. So by the time that you are done, when you are on the defense side, and what I thought was great learning experience that a lot of new plaintiffs lawyers do not have, is you learn how to work up the case, and you learn how to be a really good lawyer. So that's what I took away from the defense side. Now I changed. All right, I made a determination in '96 that I was going to go and change over to the defense side. And everybody asked me, they say, okay, why would you make a decision like that? And it was actually pretty simple. I had been a defense lawyer for manufacturers as well as insurance carriers, and I had the opportunity to do 6, 7 different trials during my first 5 years of
Mm.
practice. And I was working on a case and defending, I guess I can say it now, Ford Motor Company, where somebody was injured, and we were going to trial on the case. And at the conclusion of the case, we were very successful. And my wife came to me. She said, "Do you think you could have done a better job if you were on the plaintiff side and made
Mm.
some money for the person that was actually injured and hurt?" And I remember that at that point in time, thinking like, because the plaintiff's lawyer wasn't that great, put it that way, and the person that was injured horribly, and probably in all reality deserved more compensation. And that was the first time that I actually thought about it, and I thought, yeah, you know what? I think I could have done a better job. And so I changed hats. I put on the white hat, and I started looking around for firms that were on the plaintiff side. And I got lucky at that time. I mean, I got hooked up with a firm before I came to Panish and Boyle. The name of the firm was called Engstrom, Lipscomb and Lack.
Mm.
And I worked with Walter Lack, and they were doing all plaintiffs cases at that point in time, and learned a lot from them for about 20 years actually, and then came over here to Panish and Boyle about 4 or 5 years ago. So that's kind of a 80,000 foot view of how I started on the plaintiff side, and how now I started on the defense side, and now I'm on the plaintiff side. But I will tell you, I'm in charge of some associates that work with me, not under me, but certainly I'm responsible for training them. And I think one of the things that I've taken away from the defense practice is training them in the right way. Because as a plaintiff's lawyer, your first year, a lot of times you go to different firms, you're just kind of learning on the run. You don't really know what to do. You don't think about keeping in contact with clients because that's your ethical responsibility. And at least advising them of the high points and what is going on. So we're working up a case now. We have a certain procedure that we go by to make sure our clients are informed. A lot of our referral lawyers, we have a lot of referral lawyers. We want to keep them informed and making sure we're doing the things on the case to make sure we can represent our clients the best possible way.
So, first off, very interesting career. I think that going back and forth between, or not back and forth, but making the switch is very interesting. As I was telling you before we got on camera, I too, I mean, I haven't worked at a defense firm, but I have had some rather intimate defense side training and introspect, and it was just such a wildly different thing than what I would have learned from just listening to plaintiffs' attorneys. So, and I'm sure the vice versa could be true too, but listening to you speak, it certainly strikes a chord with me in the sense that I understand where you're coming from when you say a lot of plaintiff attorneys maybe look, if you want to be a personal injury plaintiff's attorney, you just snap your finger, hey, I'm a plaintiff's attorney in personal injury. There's no gate, there's no bar to that. Anyone can open up their own shingle. Heck, I did. But with that comes a lack of training. With that comes maybe they picked up something here or there. They went to an MCLE, and they probably went to an MCLE which was presented by other plaintiffs' attorneys. You get what I'm saying?
Exactly.
So it's this, and I'm sure there's things of this nature on the defense side. I'm sure everyone gets siloed to some extent, but I'm so thirsty to hear about some of the differences, and let me maybe give us some direction. I'll put something on the table, and you let me know. One of the things when I started getting defense side training, one of the things that became evident to me was the person who I was speaking with looked at things in the big picture more than myself and most of the plaintiff attorneys I spoke to. Whereas the MCLE I went to last week, And my entire focus this week was this one motion to compel. She's saying to me, look, we know you're going to file this motion to compel, but you might miss the deadline. You might not do a good job. You might blow it, and that might let us withhold the information. And I said to her, well, wait a minute. Are you willing to risk that? I says, A, a lot of plaintiff attorneys don't file the motion to compel. So by our nature, we're just going to withhold to begin with and hedge our bets. I mean, it's almost like they looked at it statistically. And that was eye-opening for me. Does that any of that mean anything to you or strike a chord with you?
Well, it resonates with me. It resonates with me when I worked on the defense side, and it resonates with me actually when I'm on the plaintiff side now. Because I think that there is a thought pattern, if you will, from the defense side that would start off when I was working on the defense, and we'd send a bunch of interrogatories out. We would get interrogatories to us, and we'd get requests for production. And a lot of times, what we would do is that we would just object to all the requests. And that was, and if you object to all the requests, like most people know out there, well, or we give 1 or 2 word answers, or produce one document but withhold the other 99 pages, and say that we're withholding it based upon privilege or whatever it would be. And what happened a lot of times, because there's a lot of plaintiffs lawyers out there, you don't have time sometimes, or you don't review the responses, you waive your right to bring a motion to compel. Does that happen now in practice when I'm on the plaintiff side? Still happens all the time. And we look at discovery responses. In fact, we had a meeting about it in my little group that I have. And I said, when those responses come in, let's review them. Let's make sure they're sufficient. Let's send out a meet and confer letter if they're not. And listen, all lawyers make mistakes. Sometimes you don't follow up on the initial written discovery to bring the meet and confer, but you haven't lost at that point. There's other things that you can do, and that includes taking the deposition of the person most knowledgeable, sending a request for production of documents with that. But yes, to go back and make sure that I answered your question, I think there is a thought pattern on the defense, at least that was ingrained in me at that time, is, hey, 2 things. Number one, we want to do it as cheap as we can, but we want you to do as much work as you can, because they didn't like paying a lot. They didn't want to even pay the lawyers that much. So they constantly review your work and your bills. The next thing was, if you could take advantage of the plaintiff's lawyer when you were on the defense side, that was your job. And that's what you would do. And that would mean withholding documents. And if they didn't object to them, they didn't bring a meet and confer, and something that could put your client in the best position, that's what you were supposed to do. And the other thing that I had a little bit of problems with, I think when I was on the insurance defense side, it seemed like, and is, that we were more or less beholden to the insurance company, not necessarily to the client. And your job as a defense lawyer is to inform the client and make sure the client is informed and representing them. And the insurance carrier is there, and I understand that the position they're in. But the reality of it is, and what I didn't like as much, is I just felt that it was more of a relationship that you had to have with the insurance company, whether they liked you, whether you were doing what you were supposed to be doing. And after about 4 or 5 years was when I kind of looked at that, and it kind of soured me a little bit.
Yeah, I another defense attorney who has been kind enough to kind of give me some insight. I mentioned to him, look, what if this gets your client in trouble? What if it makes the client look bad in public? And he goes to me, he says, look, I get that's the client, but the insurance company who's paying the bill doesn't care about those things. And I guess that then rolls over into kind of my concept of corporations. Corporations are designed to make profit and minimize losses and costs. And of course, that's what we incentivize corporations to do. I'm not suggesting they shouldn't, but what I think we're both getting at is there could be a somewhat ethically grayish zone there in terms of who you truly have a fiduciary duty to and who should be guiding. I'm sure there's been plenty of cases on the defense side where the defendant themselves probably wanted to settle, and it was the insurance intermediary who was like, not over my dead budget. So
Happens all the time.
yeah, yeah, I think I have one of those right now myself. So I'm familiar with that. If I said to you, when you were on the defense and there was either a tactic, a strategy, a pattern, or something that you consistently see plaintiffs' attorneys making this mistake when you were defending cases against them, what would that be?
I think the pattern by the defense is kind of what we've already talked about a little bit. I think what they attempt to do and what we attempted to do at the time was overwhelm a lot of the plaintiff's attorneys with a lot of written discovery and not providing the information which we were supposed to provide. Because I think the idea when I was on the insurance side, one of the first things they would ask, or when we would get a new file in, here's the plaintiff's lawyer. We don't know anything about him. Looks like he's from a small firm. Blah 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 blah. If it was a plaintiff's attorney that they respected and liked, here it is. It's Mr. So and so. We respect him. So there was an idea that we saw, or that it was out there in the insurance company's mind. Hey, if it's the little guy, we can take advantage of them and get a better settlement than we ever would if it was, Mr. Right on the other side. So it was just it was a constant mindset, I thought, when I was there, that, okay, so we've got lawyers over here that are really good, whether it be Brown Green or Michael Hughes or whoever, Brian Cavadat. I mean, we have these lawyers over here. It's a case that's filed. Let's take care of it. Let's get rid of it. Give them a call. Let's go a shorter route. If it was another lawyer that was on the other side that they'd never heard of, it was, totally looking at that and putting a very aggressive litigation tactic on them to put the most pressure on them just to settle the case, regardless of whether liability was clear or the damages. So that's kind of what I saw out there. Over here at Panish, Shae and Boyle, I'm kind of lucky because they have an established name. So most of the carriers out there, most of the defense lawyers, we know. And so we don't have those kind of tactics. They're more or less, everybody is above board. We know where we're going on the case, and we know where the information that they need. So it makes it much more enjoyable, if you will. For example, if I was just out on my own, I think it would be a little bit different type of practice, and they would treat me a lot differently than if I was, not under the cover of Panish and Boyle.
Yeah, if you're a solo like me and you're listening to this, I will say this, I will always say this, that first phone call with the defense attorney is important. And I think you always need to be aware of the law and present yourself, because I notice a trend of them misstating the law during those first phone calls, or saying saying
Right.
things that just not sure that's how it works. That sounds like an MSJ issue, not a demurrer issue. That
Right.
doesn't sound like, yeah, sounds like you're gonna have to litigate this one for a while. That first phone call, or sometimes the adjuster calls you, especially when I just started, I would file a case and an adjuster would call me and they would be really nasty. And they kept asking me for information. I was so confused. I didn't give it to them. But certainly these types, I think reputation counts. It's something that my defense attorney friends have brought to my attention, both on the employment law world and in the personal injury world, that they monitor people. They have a sense of who's who. They're testing you. And even with mediators, I think I could make, sometimes I think mediators misstate the law that they know is wrong on purpose, just to see what you say. So when you go, sometimes I think a lot of lawyers, and you tell me what you think about this, Paul. Sometimes I think a lot of lawyers look at the practice as more of a business than there is lawyers who look at it as more of a craft. I think if you're not actually putting the time in to learn the actual law, if you don't find ideally you find some pleasure in that. And I think that that's very helpful. What do you think?
I think this, and I've always thought about this. We've had some big cases that we win, and they're in the news and all this kind of stuff. But the reality of it is when you're working with a client, and I just some of them are coming to my mind right now as I'm talking to you. There is a point, and that point comes very, very quickly where um, you are working for them because you are concerned about them, and you're concerned about where they're going to be for the rest of their life. And once that threshold is met, and it's met very, very quickly, when you have your first client meeting, you decide to take this client under your wing. The economics, or the business side of it, if you will, that all kind of goes out. And
Mm.
in fact, you don't even think about it. And you're thinking about, have I done a good job for my client, who, after my representation is done, are they going to be taken care of for the rest of their lives? Or are their injuries going to be paid for? Because I'll tell you, I think there's lawyers that look at it like that. And that's just kind of lawyer that I am. It's kind of how I was brought up. And other ones look at it as a business, and they're over there counting numbers and how much did you make here or not make here, whatever it's going to be. I never worried about the latter, because I really truly believe that if you're just invested and you're all in, that at the end of the day, the best result is going to come out, and the economics will just work themselves out. And that means, for us, or the way that we have done it over here. I mean, there's hundreds of thousands of dollars that we have spent on cases that, before they even touch or go to trial. And you do that because we're lucky enough to have the financial backing, but you also do it because that if you lose those cases, you don't get it back. So why are you doing it then? Well, you're doing it because you have a client that's been truly injured, and deserves his day in court and justice. And so I think if you think like that as a lawyer, and I think that has to be, it's a little bit of born and bred in you, but I think it should also be taught to you. And if you're thinking that way, it's not a business. It's a business at the end of the day, when you're reconciling your cost at the end of the year for taxes or whatever it is. I get that, and I'm not really talking about that. But what I am talking about is all the work getting up to that point, is putting a client that has been injured first, and making sure you're doing everything that you can do for him. And if you're doing that, the business side will work out.
Yeah, it's soothing to hear you say that. I think rolling with that, I think there's something to be said. I don't know if everyone who practices really enjoys the fact that they're practicing. And I think maybe that spills over into why one person thinks about the client and why the other person thinks about the bank account. That might have something to do with it. But anyways, we digress. I want to go to that gold mine of information from your defense experience, switching over to your plaintiff's experience. Let me go back to the original question. Let me thread it out a little bit here. So I understand that you've explained to me about the mindset or mind pattern. I'm not sure the exact word you used, but or thought pattern. But here's a very specifically, is there a mistake that plaintiff lawyers make, whether veterans or novices? When you were on the defense side, you're like, we keep getting them with this particular tactic. Was there a thing, or is it a mixed bag?
Not one particular thing really rises up to make me think. It was almost a combination of things. And like, and I think your question comes from, okay, and in every case, is there that one silver bullet, if you will, that the defense is looking at, or if they can get to that point, that that's what they'll try on every case, with regard to, no matter who the lawyer is. And I don't think so. I really think that these insurers are fairly smart, and I think when you talked about a business, and we just got done talking about that, that's all they are looking at. They are looking at the business formula for, okay, how much money do we have to reserve for this case? What are, the lawyers are going to get paid X amount. And can we get out of it for cheaper? And will my lawyers that I am working with aggressively litigate and try to take advantage of plaintiffs that we can to make sure and save from the bottom line? They are not looking at clients, I don't think. I think they are looking at a amount of money that is there, and trying to make sure and not pay out. That's how I feel about insurance carriers, and they only pay out when they are forced to pay out. And so, some people have said, it's funny, so some of the people that I knew when I was a defense lawyer, when I became a plaintiff's lawyer now, and I've been a plaintiff's lawyer for the better part of 23 years. So, Paul, you got so jaded on the plaintiff side, because now I look at the defense and the insurers, and I have an idea of what they're going to do. And what I mean is what they're going to do at every step, whether it be discovery, whether it's going to be trial. And also, a lot of times when I was on the defense, we were somewhat hamstrung a little bit, because they didn't want to authorize maybe some of the things that you needed. For example, when I was on the defense, I was trying cases, I would, spend 5-6 hours putting together an opening statement. And we'd go and do the opening statement, we'd win the case, and I'd come back, and you have to submit bills, and they would cut that down to an hour and a half. And then my firm, would say, oh, they cut this bill, blah, 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 blah. So there were always things like that you had to go through when you were on the defense side, because they are more or less, to me, bean counters.
Yeah.
That's what they're looking at. Where we're, I think, looking at the plaintiff and the injuries and trying to get compensation from that. They're over here saying, how much money can't we spend? What can we save? Are we going to have to pay out here? So I don't think it's one thing. I don't think it's a silver bullet. I think it's just a whole way of the way insurers think. And I think my 5-6 years there, Daniel, probably like you start looking at that, and you have a pretty good idea of what they are taking into account and what they want to do. And it's an opposite to what we do as plaintiffs lawyers.
Yeah, I would imagine so. I do appreciate my friend's defense firm. They had some incredible macros they used in Microsoft Word. That seemed very efficient. But aside from that, I agree. It didn't seem, the way they went about it just didn't seem. I think I go about it in a manner similar to you. I'm compassionate. I admit my heart bleeds for my clients and the circumstances they're in. And based on that, there's a sense of, and you're only confirming this, there's a sense that no one's ever going to give you what you deserve. You kind of have to go and pull it out of people. I would imagine if insurance companies actually paid out on injuries and issues and this and that, what things were actually worth, the finances of the insurance company would be very different as a result. Let me ask you this. Let's bring it back over to the plaintiff side. What is it now that you're looking at things maybe from the plaintiff side that you think the defense misses?
I think what the defense misses is this. One of the things that I think in almost every case that we have is the defense has not and do not understand who their own clients are. And here's what I mean by that. As plaintiffs lawyers, we have a pretty good idea who our clients are. We meet with them, we sign up the case, we have a case information sheet that they fill out, so we learn everything about them. And we learn about the good and the bad. I think what the defense lawyers don't know, or the insurers don't know, is who their clients are. And what they find out really for the first time when we take the deposition of the defendant driver of a truck or a defendant in any particular case. Because
Interesting.
what ends up happening, and I'm thinking about this because of all the depositions that I've taken, where I get a call from the defense lawyer after or whatever, says, this is not a very good case. Now I got to report it to the insurance carrier, because the insurance carrier have no idea really who their client is, or what they've done or haven't done. And when you and I take a deposition on the plaintiff side, we do an investigation of the defense. Not only do we get their interrogatories back and things like that, but we do internet searches and make sure that we get every little detail. At least that's what we do over here as plaintiffs lawyers. When I'm taking a deposition, I'm thinking that these are the questions that I'm going to ask at trial. And I write out those questions that I want the answers to, so that I can make sure and check with the jury instructions, so that we are going to be successful when we get to trial. So that's how we take depositions over here. So one of the things that I don't think that they are prepared for is the deposition of their client and how we take depositions over here. I think it's a big deal. I'm a big proponent of taking depositions, and I'm a big proponent of taking them just like you would take them at trial, because we videotape them and we use those depositions at trial. We use them during our opening statements, and it's very, very effective. So I think when you ask me the question, I always hate to go back and not answer the question. It's like watching a debate, watching the debate the other night. All these questions are asked, you never get an answer to it. But that's what the defense really doesn't know or consider or prepare for, which I think changes the course of any particular case.
It's an interesting point, because earlier we were discussing how the insurance, at least, is probably more concerned with the value of the case than they are the actual defendant themselves. And you're saying that that may have a follow-on effect. This might be the trickle-down effect of that, which is they really haven't put the time into actually finding out who the defendant is prior to the deposition. And I agree with you. I mean, depositions, it's hard not to get good evidence from a deposition, in my opinion, because you have the opportunity to ask someone every question, every which way. Let's talk about depositions, because I'm curious, especially with a guy like you that has experience on both sides of the aisle. What is your view of depositions in terms, just like big picture? How do you like to approach them?
Depositions, I think, are one of the things that I like I like the most. It's one of the things that I've taught different courses on, and have attended different courses on different questions and different tactics. From an overall view, when I am going to take a deposition, I will tell you what I do and how I instruct my associates when they're going to take a deposition. And one of the things I tell them is, I want you to write out 2-3 sentences, bullet points, whatever you want. What are the 2 or 3 things you want to get from this deponent? And that's my big picture at that point. And then after you're done, otherwise you see just somebody that's kind of going in there and fumbling around. And you can certainly, I tell them, you can fumble around all you want, but if you got answers to these top 3 or 4 questions, those are the depo clips that you're going to play at trial. Those are the cross-examination questions that you're going to ask the deponent when he gets on the stand. And that if he goes sideways on you, you're going to use his deposition to cross-examine him. So there's always about 4 or 5 usually good things that you're trying to pull out as nuggets that will always be useful, whether it be in a motion or whether it be for the time of trial or for cross-examination. So that's kind of the 80,000-foot view, how I look at depositions and what I want to do and what I want others that I work with to do. Now, how to take them is another issue.
Sure. Let's switch to tactics. What do you have any feelings in particular on? Because I think we were just discussing strategy. What about tactics? Anything like a particular method you like to go about things, or anything at all, really?
Yeah, I definitely don't have a certain way that I take depositions all of the time. you learn this as a defense lawyer and even as a plaintiff's lawyer. You start out, you introduce yourself, you give the admonitions or the rules, you go through the background, you go through the education, you go through their employment experience, then you get to the incident and you ask them about that in a chronological order. And I think that's generally, the way to go about it. I've had other depositions where once I tell them the admonitions and swear them in, I don't do any of the background and get right to the incident, then do the background at the end. So I switch it up a little bit depending on who I think the witness is. But there are for each deposition is different, and what we do is craft. And I really think there's 5 or 6 different questions that you can ask them where they're going to make a difference in your case. There is another way to take depositions, and the gentleman's name is Dodd. Forgot his first name already. Last name Dodd, and he has a school where you could take 3 or 4 days where he teaches you how to take a deposition.
Interesting.
And the way that he does it, and it's very effective for purposes, I think, at least for taking a deposition or trial. And that method is like this. And I don't want to tell you exactly what his method is because I'm not going to say it verbatim, but there's times when you can go in maybe as a lawyer, and after you put the admonitions down there, it's 100% almost cross-examination. And most of my depositions are cross-examination anyway. For example, instead of saying, isn't it true, all of the sentences are shortened up. And I'll just go through an example would be, you were born in 1950. Yeah, you're 75 years old. Yes. You went to school at Laverne High School. I did. You started there in 1983. Yes. Graduated in 1987. Yes. And you ask questions like that, including up to the time of the incident. You were involved in an incident in 2023. Yes. That incident happened in May of 2023. Yes. And you were at the corner of Laverne and Norton at that time. That's right. And the time was approximately blank. Yes. And so they're all questions like that. And I've taken a lot of depositions like that. And that way, when you're going back, especially if you're trying to get, it's a negligence claim or whatever it is, you have yes, no questions on all of that. Where you don't have a witness, as you know, where you probably goes off on you, can talk for 2 or 3 pages. About what time did the incident happen? You have a witness that goes, well, it's around 2:30, maybe closer to 3. And, I know that because the light went on and my alarm was on at the time. And I got a call from so-and-so. And you all of a sudden get an answer that is unusable at the time of trial. And so what that has taught me, the Dodd School, was I was already pretty much a cross-examiner anyway. I believe that if you go into a deposition, there's 2 things that you want to do. If there's information you truly don't know, then you have to ask, what about this? What about this? What are all the documents that you have regarding the incident? Do you have an incident report? Yes, I do. Where is it? Who knows about it? All that kind of stuff. And then the other way to do it is, to really cross-examine them and put them in a box. So for purposes of trial, you have that information. And so I'm pretty aggressive during depositions. I believe when I get the police report in and it's a clear liability case that we want to establish that I ask questions. You admit you're at fault. You admit you're 100% at fault. You admit that my client has done nothing wrong. In other words, he's not comparatively at fault, right? No third party is at fault. That's right. And if he goes down the other path and says, no, I'm not at fault, and you have witnesses like that all the time. I think there's just follow-up questions in that area, questions that are you telling me that you don't even accept 1% of the responsibility for the accident? Not even 1%? And then they say no, or whatever it is. So there's different avenues, as you know, as a lawyer, when you've taken a lot of depots that you can go down. So when I'm training people that I work with, it's a training process because they can get the outline and ask the general questions. And then the real question is, once you get somebody who goes a little bit different way, what do you do with that? And that's part of the learning process of being a young lawyer.
So to kind of summarize a takeaway, it sounds like you like to ask rather straightforward factual questions which get a yes or no answer for the purpose of maintaining that record and presenting it easily at trial, versus when you get a convoluted answer from a defendant or from a deponent, I should say. It could be a little bit more difficult to present that, whether to a jury or to get it past a judge. Am I hearing you right?
You are. Yeah, I mean, that's exactly how I do it. And I'll stick on a topic for a long time and I'll ask the question 5 or 6 different ways.
Mm,
And I'll be honest with you, what I'm looking for is sound bites. And I'm looking for sound bites for the trial. I'm looking for those phrases where you say it enough, where you get up an opening statement and you're using those phrases or during the voir dire process.
mm,
And that way, all of a sudden, the jury hears it from the witness and it means something.
I see.
So there is a thought process that goes into it that takes, several steps ahead and says, okay, what do I want to do with this witness at the time of trial? What am I trying to get out of them? And there are times, when you got some really, really good witnesses and they're going to be believable. And as you know, when you're on the defense too, and this is what I also think about with regard to depositions, let's just not talk about a defendant, but also my client. You know, I know now when I used to take depositions, that I used to go back to report to the carrier and I'd write a letter. And the first part of that letter is impression of the witness.
Hmm.
Mr. Smith appeared here. He was on time for his deposition. He was nicely dressed. He was articulate. He is going to make an effective and nice witness in front of a jury. That's the first thing that is written to any carrier,
Mm,
at least it was when I worked there. So when I'm preparing my clients on the plaintiff side, we talk to them and we tell them, dress nice. Doesn't have to be necessarily a suit, but it's going to have to be a suit coat and a collared shirt. And I want to tell you what they're going to do with your deposition testimony. First thing is going to be impression of the witness. That's what they're going to do. And I want them to go back and tell them how good you are. And so we have to talk about what makes you look like that. And so that you're not speaking over people, that you're going slow, and everybody's different, but we take them through that deposition process. So when they're sitting for the first time, on Zoom deposition or face to face, it's easy for them. And in order to make it easy for them, you have to prepare them like there's no tomorrow. And most of our clients come out after a deposition and say, "Oh, you were a lot harder on me than the defense was," and that's what you want them, to say.
yeah,
So
it really, the amount of effort it takes to prep someone for a deposition really is an undertaking. The difference in the way lawyers and non-lawyers speak and how evidence works, and not answering more questions than the questions that are asked, and not going off topic, not rambling. It is an undertaking, and one that I don't know, you tell me this, but sometimes I get the feeling a lot of plaintiff attorneys are rather casual about prepping their own clients.
I think you're
That's just
right.
me.
And, one of probably the most important parts about a case is your client. They're the ones that are actually telling the story. And I think it's interesting because when it comes time for their deposition, um, they can be shortchanged. In other words, you can't spend enough time with a client preparing them.
Mhm.
And they don't know. I mean, our clients aren't lawyers, and they didn't study the law for 3 years and then take a bar exam. Most of them have never been in court before, and they certainly haven't been cross-examined. And they don't know, I don't want to say how to testify, but they don't know what the process is about. And we spend about 45 minutes or just going over the process of them. Here's the process. Here's your 80,000 foot view. Admonitions, background information, They're going to talk about the incident, then they're going to ask you about your injuries. So let's go back to this word, this admonitions. It's really just the rules. And we go down and talk about that with them to make sure that they're very prepared. And you know as well as I do, when they're being deposed, the first thing the lawyer says, I'm going to have you been deposed before? And let's talk about the rules of a deposition. And all of a sudden your client's going, hey, I just went over this with Paul for the last hour. This is exactly like it's going. And the other thing we tell our clients is everything's in chronological order usually. We're going to go through the rules. We're going to go through your background. They're probably going to ask you when you were born. Okay. Then they're going to ask you about high school and college, other certificates, where you were first employed, and they're going to go through your employment history. The incident always starts with what were you doing that day? And so once I think it's more or less understanding the process so that they're not surprised by anything. And then they're comfortable with it because that's how the depositions are taken by the defense. And then the next part of it is, well, they may show you some documents. Let's show you some of the documents which you signed or didn't sign or whatever it's going to be. And then you go through some of the discovery responses with them. So when they pull up the interrogatories, the defense does say, have you ever seen this before? This is your verification at the end under penalty of perjury. Yes, yes, yes. And you put down this for whatever it was, 12.1 about your injuries. You didn't say anything about your neck injuries. And you could, we tell our clients, just tell the truth. I didn't put it down there. Does your neck still hurt? It does. It does. And how come you didn't put it down there? Says, I just didn't catch it. I didn't catch it. And that's okay.
Yeah.
But what I think is important about the process is, number one, that it's the most important process, I think, as a part of the case. And second, that they just need to be prepared so they feel comfortable when they're being deposed.
It's interesting that you bring up their comfort. The notion that they're familiar with what's happening. To me, this all sounds like there's almost like a psychological concern for the client, in the sense that a client who's panicked and under incredible pressure and fidgeting their hands under the table and sweating is probably not going to give the best testimony. They're not at their best and their brightest. Whereas the deponent who has had your prep is like, oh, this is what Paul told me, those admonitions or whatever they were. Yeah, here they are. And foresees what's coming up. That's got to do a lot of good in terms of cooling down any nervousness they might have, thereby producing, I can only imagine, a substantially better testimony.
I think that's just so important. And all clients are different. Some of them, no matter how much prep they're going to have, just don't come across very well.
Yeah.
That's just part of what the world is. And as a result of that, it affects the end of the case. But each one of them deserve the best that we got, and the best advice that we can give them, and the most help. And our job as lawyers is, being a lawyer, going into a courtroom. But I think on the plaintiff side, it's putting their mind at ease and trying to take the pressure off them, because, we do this every day. They don't. And all of a sudden, when they come into our world, it's not that much fun for them. This is not fun for them. They're not happy to be there.
No.
And they know that they have to be there. And so this kind of just how it looks, I think. So when they come into our world, I think it's our job to make them feel as comfortable as possible.
Yeah, I have 2 clients I got to call after we do this podcast. I know exactly what I'm going to say to them. I'm like, aren't you happy to get a phone call from a lawyer at 5:30 p.m. on a Friday? What more could you possibly want? Right? I mean,
couldn't be any better than that.
Yeah. Winning lottery. You've already won it.
Exactly.
I understand our field is probably far from what the average. I think we have very strange but interesting jobs. And I think what's interesting about law is it's adversarial, and most professions are not. So it lends something to it that seems to maybe just to take it back to the previous point, it lends something to it where I can understand why someone who's on the hot seat at a deposition would be nervous, but for proper preparation.
Yeah, I think I think you're right. They're nervous even with proper preparation. They're just always worried about what they're going to say, or did I say it right? And I said, don't worry so much about saying it right. Just tell the truth. I just want you to know what's coming, so that you can say what you want. You want them, I think, to bring out their best possible self. And the great thing is, and I tell them this all the time, um, if need be, and some lawyers don't think this way, but if need be, I will ask you questions at the end, and I've done that several times.
So you don't shy away from that.
I don't. I used to think, oh, it's not going to help. But there's a situation, especially in personal injury cases, where our clients are asked the question, well, how you feeling now? Okay, we as lawyers object to that. It's overbroad. It's this, it's that, but they still have to answer the question. Sometimes they say, "I'm doing better," and that's kind of a problem, because all of a sudden you get to trial, they use the deposition transcript. I asked the question, how you doing? And you said you were getting better. Today you come on the stand, you're telling me about the 8 different problems that you have or continue to have. And that creates, a difference in deposition testimony and could affect the case. So I always go back on and say, you were asked about how you were doing today. You said you're doing better. I want to break that down. I want you to tell me what injuries that you have. And then I go back in and tell them I want you to tell me what the injuries, how the injuries you have, how it affects you when you get up out of bed in the morning. I want to know when you pull the sheets off, is it harder, to swing your legs over because of your back injury, because of the fracture? Yes, it is. Tell me about that. And I had to make them tell me. Then I say, you stand up. How does it feel when you stand up? And they'll tell me that. And I'll say that. Do you go over to the sink then? Yes, I do. I brush my teeth. Yeah. How do you feel at that point? Well, it hurts when I bend over and it's hard to straighten back up. Do you get in the shower? I do. Tell me about how it is when you're getting into the shower. And I go through a day in the life with them, so that we can never have a defense lawyer that is going to have them, constricted to their testimony because they didn't explain the injuries that they've suffered, how it's affected them. And it's such a big deal in a personal injury context, because our clients get very tired, I'd say, after about an hour of the deposition, and they're lulled into a sense of false security, because everything's about their background, and they feel good because they get to talk about things they really know and have thought about. And the questions regarding their damages and things of that nature don't come until the end, when they're really tired. And a lot of times it's just, get me out of here. And I don't allow them to. I don't allow my clients to do that. So yeah, I do ask questions at the end if need be, because our job as plaintiffs lawyers is to make sure and get that story out. Because if that whole story doesn't get out, it could hurt us at the time of trial.
Yeah, like, not only that, if a case has a chance to be resolved prior to trial, because I've had this debate many a times. Do you ask your clients questions at the end of a deposition? I typically don't, but I don't do the sort of absolutism that I hear a lot of lawyers say, which is never under any circumstances. And the best response to why that is, I've heard, is, look, he or she can always testify to that at trial if they didn't ask that question, for example, or they didn't fish enough to get the information. You can always produce it at trial. But if there's a chance for the case to resolve prior to trial, don't you want them to know that information? Isn't
Yeah, I
there?
think so. And I know the feeling out there is, don't ask your clients any questions. I think
Yeah.
that's the general feeling that you would ask, probably 10 lawyers, and 8 of them would say, I don't need to ask them questions. And I certainly don't need to ask my questions every time that they are deposed. It really depends on the questions that are asked. But I'll tell you, I think you kind of hit a kind of the high point of it. I mean, if you're really trying to get out everything, and if you have a client that is really good at testifying, but they're not telling everything, and things that can help, I think it's your job. Why not put it out there? How does it hurt you?
Yeah.
I've always asked that for so all of the 9 lawyers that would disagree with
Yeah.
me, which is fine. I'll say, how does it hurt you? In all honesty, how does it really hurt you? I mean, your case is based upon, most of them we do is personal injury. I want you to talk about your injuries. I want you
Yeah.
to talk about what you can't do now, what you used to be able to do. And I want you to go in depth about it and tell them about everything. And so we prepare on that, but sometimes even when we prepare, they don't do it because they're just done. So in any event, I do ask questions. I think it helps. I think it helps the case. And I think it helps it gets out what is really the truth. People that are injured and going through injuries on a daily basis, it's really hard for people. And I'm gonna say it's not to be sexist with guys. I can't get the guys to talk about their injuries
Yeah.
unless I ask them questions. And I know because I'm getting older how injuries affect people, of course. And that effect is, oh, my elbow hurts, it just kind of hurts. I can't throw the ball anymore. To when you start really grinding down them when you're preparing, they can't sleep at night.
Yeah.
Or they have to sleep at night and wake up at 3 a.m. and take a pill. They do that every night. And then that pill's only good for 5 or 6 hours. They have to take it again. And then the pill then makes them feel loopy or whatever it is. So it really is something I think as a plaintiff's lawyer where you say, I got an elbow injury, that boils over into a lot of other things that you can only get the story out by asking them those questions. And I don't think the defense is thinking about that because they just say, okay, he's got an injured elbow. He's got to go through physical therapy. It looks like it's going to be better, blah, 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 blah. And they forget about all of what I'll call pain and suffering and the pain and suffering that they have to go through and what they go through on a daily basis. And we as lawyers, when we are showing the injuries that our clients have suffered, have to talk about the pain and suffering from the day of the incident up till trial and what they've had to go through. And that's for each one of the injuries. So I like to get it out. I like to get it out at depo. It should be in our form interrogatory responses
Yeah.
anyway and documents. But, listen, as you know, having a client testify at trial about it is, whether it's compelling or not, can change the way that the jury views the evidence and whether your verdict is good or not so good.
Yeah, absolutely. Absolutely. I appreciate that. Having a lot of fun. It looks like we've gone an hour. It's kind of
Okay.
surprising to me that it feels much shorter than that. I'm really enjoying. I enjoy sincerely these types of conversations, getting into the nitty gritty of the law, speaking to someone seasoned such as yourself, someone who has a wide array of perspective. It's appreciated, Paul. I would love to have you. I appreciate your time today. It's been generous. It's been an hour, like I said, but we would love to have you come back on and just discuss various areas of the law in the future if you'd like to come back.
Well, first of all, I'd love to come back. I love doing this, Daniel, and I really appreciate you giving me the opportunity to be here. It means a lot to me.
Of course, Paul. My absolute pleasure. It was very nice to meet you, and I was very much so looking forward to this date. And frankly, it's more or less everything I expected. I figured we would talk shop, and we did. And I look forward to doing it again.
All right. Take care, Daniel.